Welcome to In Camera, Hollywood Scandals, Legal Truths. I'm Adriana Collado, movie fan, history buff, criminal defense lawyer. Join me behind the scenes of Hollywood's most controversial criminal cases and uncover the hidden stories, excluded evidence, and legal tactics the public never saw. Let's go In Camera.
February 6, 1943, Los Angeles Superior Court. Errol Flynn, Hollywood's hottest leading man, the face on every war bond poster, the man women wanted and men wanted to be, walks free after being acquitted of sexually assaulting 2 teenage girls. But consider this, not guilty does not necessarily mean innocent. What it does mean is that the prosecutor couldn't prove the allegations beyond a reasonable doubt. And in Flynn's case, the reason why had nothing to do with what actually happened. It had everything to do with who was in that courtroom, how they got there, and a defense attorney's savvy moves. In 1943, Errol Flynn was kind of a big deal. He wasn't just famous, he was a phenomenon. Born in Tasmania in 1909, Flynn came to Hollywood in 1935 and soon became Warner Brothers' biggest gamble and biggest payoff. Cast as a swashbuckling pirate in the movie Captain Blood, Flynn became an overnight star. Then, Flynn cemented that image as the daring, charming hero in the adventures of Robin Hood. If People magazine had existed in the 1940s, he would have been their sexiest man alive several years running. But off-screen, Flynn was no hero. Heavy drinking, drugs, endless sexual conquests. He wasn't used to hearing the word no, especially from women. And the studio system shielded him from consequences because he was a cash cow. Flynn was, as one reporter put it, a man who got away with things because people wanted to like him. That image, dashing yet charismatic, dangerous yet lovable, would be tested in the fall of 1942 when 2 teenage girls came forward with allegations that would have ended any other man's career. Their names were Peggy Satterlee and Betty Hansen. Let's start with Peggy, because her story came first and because what happened to her complaint is a bit of a story in itself. Peggy Satterlee was born in Dallas, Texas in 1926. A pretty brunette, she found work in Hollywood as a dancer and actress. She'd gotten her foot in the door, landing a bit part in a movie called Arabian Nights. Peggy met Flynn around August of 1941. Now, the first day they met, Flynn asked Peggy if she'd like to join him and several others on Flynn's yacht over the weekend. Excited? Peggy said yes. She was 15 years old. According to Peggy, here's what happened next. On Flynn's yacht, Peggy was assigned a small stateroom with 1 bed. After dinner, Peggy retired to her stateroom, passing Flynn as she went downstairs. She kissed him goodnight on the cheek, then undressed and got into bed. Shortly, Flynn showed up and let himself in. Peggy remarked that it wasn't appropriate for him to be there, especially since she was already in bed. Flynn then proceeded to sexually assault her despite her protests. After, Flynn saw that Peggy was crying, so he brought her a robe and a glass of milk. He then left Peggy standing alone by a rail, where she stood for a long time, not going back to bed until it was almost daylight. The second night, Flynn lured Peggy to his cabin, under the pretext of showing her the moon through one of the portholes. There, he assaulted her again, but this time, Peggy fought back, striking Flynn on his face. Now, here's an important detail. At trial, Peggy testified that Flynn referred to her by some interesting nicknames. He called her JB, short for jailbait, and SQQ, short for San Quentin Quail. Now, in case you're not familiar with 1940s vernacular, those were slang terms for an underage girl, because that's where you'd end up if you got caught with one. If Peggy's testimony was true, the nicknames proved that Flynn knew she was a minor. Peggy's mother filed a complaint with the Los Angeles County Sheriff's Department the day after the cruise ended. Police investigated and concluded there was no case against Flynn. They also reportedly persuaded Peggy and her mom to let the whole thing go. And so, the complaint was shelved. Peggy's complaint sat buried in a sheriff's file for over 14 months, until another girl came forward. Betty Hansen had recently graduated from high school in Lincoln, Nebraska. She'd moved to Los Angeles to live with her older sister and tried to break into pictures. Betty got a job at a drugstore where she met 3 young men who worked at Warner Brothers. One of them offered to introduce her to Errol Flynn, and that Flynn might be able to get her movie work if she, quote-unquote, played up to him. On September 27th, 1942, 6 days after Betty's 17th birthday, she wound up at a party in a Bel Air mansion. Flynn was there. Betty testified that she felt sick after drinking a cocktail, and Flynn offered to help her upstairs so she could lie down. Flynn then led her to a bedroom and locked the door. According to Betty, Flynn undressed her, removed his own clothes, except for shoes, and proceeded to seduce her. Betty initially protested, but soon gave in. After, Flynn kissed her goodbye and promised to call the following night. He didn't. The next morning, Betty told her sister what happened. Outraged, the sister contacted the DA's office. And when investigators dug into Betty's complaint, they uncovered Peggy Satterley's. The DA consolidated the cases and charged Flynn with 3 counts of statutory rape. He was facing up to 50 years in prison. Flynn was arrested in October 1942. It was time to get Geisler. Attorney Jerry Geisler built his name defending what appeared to be indefensible cases, and his reputation soared after the 1931 retrial of millionaire theater mogul Alexander Pantages. Pantages' charges? Statutory rape. Pantages was acquitted. In Hollywood circles, Geisler became known as Get Me Geisler because that's what studios and celebrities said whenever they got into a legal jam. By the time Flynn called, Geisler was the most feared defense attorney in Hollywood. He took the Flynn case and got to work. The trial opened on January 11, 1943. Crowds began forming outside the courthouse before the doors even opened. And no joke, medical teams were on standby in case fans fainted. Barricades held back throngs of women from teenage girls to grandmothers, desperate to catch a glimpse of their idol. The Los Angeles Times said it had more in common with a studio premiere than a court of law. Now, imagine for a moment what it must have been like for Peggy Satterley and Betty Hansen walking into that courtroom. Surrounded by onlookers, their names and faces splashed all over the newspapers, teenagers testifying about rape before a packed gallery with no protections for their anonymity. And much of the testimony was so explicit that it was deemed unprintable in family newspapers. Soon, it would go from bad to worse, thanks to Geisler's defense strategy. Let's break it down. Number 1, stack the jury. Now, during jury selection, Geisler deliberately seated 9 women and 3 men. Conventional wisdom said women would be harder on a man accused of sexual assault, but Geisler bet the opposite, that middle-aged women who idolized Flynn would distrust young, attractive girls accusing their idol of the unthinkable. He was betting on hero worship, and it was a smart play. Number 2, dissect every detail. Geisler upended the prosecution's case by attacking the smallest evidentiary details. Remember Peggy's reference to Flynn luring her to his cabin to see the moon through a porthole? Well, the prosecutor called to the stand an astronomer to corroborate Peggy's account of the yacht incident. During cross-examination, Geisler essentially turned him into a defense witness by forcing him to admit that based on the yacht's course, the moon could not have been seen from that cabin at that time. As for Betty Hansen's testimony about Flynn locking the bedroom door, Geisler had the actual door brought into the courtroom where he demonstrated that Flynn couldn't have locked the door because the latch was broken. Yikes. Number 3, slut shame the victims. With Betty Hansen, Geisler revealed that she had engaged in sexual conduct, specifically oral sex, with the 3 Warner Brothers employees she'd met at the drugstore. At that time, this was a felony under California law. The jury and spectators heard every humiliating detail. Geisler also asked Betty whether she objected when Flynn supposedly seduced her. Betty's answer, no. The implication? Betty was not an innocent, chaste young woman. She was a slut with a criminal record waiting to happen. With Peggy Satterlee, Geisler went further. He got Peggy to admit she'd had an abortion before the Flynn incident, also a felony back then, and implied she was testifying only to avoid prosecution herself. Geisler weaponized Peggy and Betty's sexual past to undercut their character and credibility. Never mind that this had nothing to do with whether Flynn actually committed the offense. Number 4, trick the prosecutor into doing your work. Now, this is a legit mic drop moment. While investigating the case, Geisler received an anonymous tip about a man named Owen Cathcart Jones. He looked into it and uncovered some startling information. Now, Geisler had to figure out how to get the details before the jury. What he did next was absolute legal genius. Geisler manipulated the prosecutor into calling the 42-year-old Cathcart Jones as a character witness for Peggy Satterlee. The DA took the bait, and on cross-examination, Geisler sprung his trap. Geisler got Cathcart Jones to admit that not only was he Peggy's boyfriend, but that on one occasion, he and Peggy snuck into a morgue. And there, Peggy, quote-unquote, frolicked among cadavers, removed sheets from the bodies, and even put her face against one of the corpses. The jury collectively gasped. Now let's go sidebar. In trial, evidence is only admissible when it is relevant to a matter at issue. The boyfriend's age and the morgue testimony had zero relevance to the charges and were highly prejudicial. I haven't seen any indication that the prosecutor objected, but I can't imagine that he'd let that one go. And even if that information was somehow relevant, today that evidence would likely be excluded because its prejudicial effect substantially outweighs any probative value. In non-lawyer speak, that testimony should never have come out because its only purpose was to make Peggy Satterlee look strange, callous, and unsympathetic. It had nothing to do with proving the allegations. But the jury heard it, and by the time Geisler was finished, Peggy Satterlee's credibility was utterly shattered. And Flynn hadn't even testified yet. Flynn took the stand and denied everything. The nicknames, the yacht incident, any sexual contact with the girls. And despite grueling cross-examination, he didn't budge. But the fatal blow to this case may have been struck by the presiding judge. While instructing the jury, the judge said that a birth certificate was only prima facie evidence of age, not conclusive. This comment left room for the jurors to infer that Flynn might have been mistaken or deceived about the girls' ages. Here's why that was a major error. Statutory rape is a strict liability crime, so knowledge or lack thereof about the victim's age is irrelevant. It didn't matter if Flynn thought the girls were older or even if they consented. The mere act of sexual activity with someone under 18 is unlawful. The judge's instruction was, at minimum, a misstatement of the law. After deliberating for nearly 24 hours, the jury acquitted Flynn on all counts. Flynn leapt from his chair and personally thanked each juror. Later, the jury foreperson explained their reasoning, and I quote, "We felt there had been other men in the girls' lives. Frankly, the cards were on the table, and we couldn't believe the girls' stories." Consider for a moment the reference to other men in that statement. Taking that statement at face value, the jury didn't acquit Flynn because the evidence failed to establish that he broke the law. They acquitted him because the girls had sexual histories, exactly what the rape shield laws are designed to protect today. Peggy Satterley gave her own statement after the verdict. She said, "I knew those women on the jury would acquit him. They sat there and looked at him adoringly, just like he was their son or something. They never did believe he was guilty." She also added that she felt like a broken old woman and wished that she'd been left out of the case altogether. She was 2 days away from her 17th birthday. The acquittal left Flynn's career largely intact, but it permanently altered how the public saw him. Now he was more of a scoundrel than a romantic hero. And the phrase, "in like Flynn," became the meme of its day, shorthand for easy sexual conquest. Flynn even joked about this in his 1959 autobiography, My Wicked, Wicked Ways. Later, Flynn's drinking and drug use caught up to him, not to mention the outgoing outbreaks of tuberculosis and venereal disease. Physically, he looked much older than his years. Errol Flynn died of a heart attack at age 50 in Vancouver, Canada. He was with his girlfriend, Beverly Adeland, whom he had met on the Warner Brothers lot. Beverly was 17. Their relationship began when she was 15. I'll let you draw your own conclusions about what that might mean in relation to this case. For Peggy Satterley and Betty Hansen, there were no second acts. Before the trial, Peggy was on the brink of a Hollywood career. After Flynn's acquittal, Hollywood was done with her. She made the rounds in the San Francisco vaudeville circuit, and in 1945 it was reported that she was planning a name change and new hair color to re-enter films. After that, the paper trail ends. Peggy Satterley died in Reno, Nevada on November 5, 2005. She was 79. Betty Hansen essentially vanished. She gave one interview after the trial and ghosted from public life. Jerry Geisler went on to represent Charlie Chaplin, Bugsy Siegel, and Lana Turner's daughter, Cheryl Crane. And in 1960, he wrote his memoirs, Hollywood Lawyer, The Jerry Geisler Story. Errol Flynn's case is a textbook example that criminal trials aren't only decided on facts. They're also decided on narrative. Jerry Geisler understood this. His job was to make the girl's testimony appear tainted and uncredible. And in doing so, he gave jurors a reason to believe Flynn's denials. Geisler accomplished this in part by redirecting the jury's focus to the victim's moral and sexual history. Now, as a defense attorney, I respect Geisler for zealously defending his client. The Constitution demands no less. And his ploy of getting the prosecutor to call Peggy's older boyfriend, that was chef's kiss. But as a woman in the age of Me Too, I'm glad we moved away from this approach. For the most part, anyway. Thanks for joining me in camera. I'm Adriana Collado. Roll credits. We're adjourned.
Like what you saw? Hit subscribe and follow us on social media. And leave a comment below. I want to hear your take. There's always more to the story. I'll see you next time in camera.